ready for another Facebook Live session. Today's session will be Rights in Water.
I don't have the video yet.
Good to go? First though, we will just go through our usual preamble, this disclaimer. The information contained in this presentation is provided for information purposes only and should not be construed or used as legal advice. Who is Baileywick Legal? You should all know by now. Baileywick Legal is a firm specialising in both agribusiness and tourism. We cover a very broad range of legal issues, business structuring, partnerships, buying and selling properties, mortgages, financing, easements, IP, and litigation issues, dealing with machinery disputes typically, and access to land issues, amongst other things. But let's move to today's topic. Today's topic, as I mentioned, was water rights. What I hope to cover today is just a few fairly broad concepts and issues that are arising in relation to water and water rights within Western Australia currently. So the first issue we'll cover is property. What is water, and does anyone have property in water? Then we'll deal with the licensing regime, options for producers where changes are made to licensing conditions, and the prospect of new legislation which is touted by the WA government to be pending. So, on the first issue, is there property in water? And we need to distinguish this from the concept of riparian rights. Now, a riparian right is a right to use water from a river or stream for household, for fairly basic household use. It's not a significant amount of water that can be used, and it must be a reasonable use. So, when we say riparian right, those people who are next to a watercourse and have access to a watercourse probably do enjoy a riparian right, which doesn't fall within the construct of the legislation within Western Australia. So it's a common law right and remains as such. In all other respects though, water is owned by the Crown. And that's a clear principle that arises out of the Rights in Water and Irrigation Act of 1914. It's a public resource, and the law in relation to water being a public owned resource goes way back to Roman times and Roman law. So it's certainly not a new concept that water belongs to the Crown in the sense that it belongs to all people. That's a fundamental principle that we need to understand, because when we get to the second issue about licensing, it becomes important to understand that a license, a water license that is simply a right to take water. It doesn't grant the licensee with any right of ownership to water. It simply is a right to take water. And in that context, we lead into this licensing process that's established by various pieces of legislation. The predominant one in Western Australia is the Rights in Water and Irrigation Act of 1914. Now, under the Act, there are certain areas which are proclaimed and delineated for the purposes of licensing water. Not every area within WA is proclaimed or is identified as necessary for the purposes of licensing. I'll say that in a different way. There are certain parts of Western Australia where a licence is not required to take water. However, in the lower southwest region, pretty much that whole area, growers in that area would need to check, because most of that area, a licence will be required to take water from a watercourse or waterway. Now, one of the issues that has come up recently when we're talking about licensing is what's known as a spring exemption. Now, growers would be aware that throughout Western Australia, and particularly the lower southwest, there are very, very many natural springs where water comes to the surface or is on the surface in a naturally occurring way. And these springs might actually, be the head of a water source, in the sense that water flows out of those springs and creates a watercourse, and which subsequently might enter into, a creek and then a river and ultimately, of course, the ocean. It was dealing with this issue of spring rights, which gave me the thought process of actually doing this recording today, and follows from a meeting which I attended down in Manjimup on the 27th of April this year, where many growers met to discuss spring rights in particular, and more importantly, the proposed legislation which the government intends to table and promote, we assume, reasonably soon. I don't know that we need to go necessarily into the detail of spring rights, but it's a good example in the context of exclusions or exemptions from the requirement to license. So if someone has a spring on their property that is not within a water course and is a naturally occurring spring, then generally there's no requirement to obtain a license to take water from that spring. If that spring actually is within an existing watercourse, then the legislation tells us that a license will be required to take water from that spring. So the exemption itself is a bit complicated. One could say potentially ambiguous in how it's being interpreted by people within the department, and of course landowners and growers have their own views on what should be applicable and whether or not they should or should not get a license as well. So that's the licensing regime in a nutshell. It's a very brief overview. Now, many growers, particularly in the southwest, have already obtained licenses. Sometimes more than one license for particular properties. Now, those licenses and the licensing regime has been around for a very long time, and a lot of licenses have been held for in excess of 15 to 20 years or longer. So there is a propensity for a person or entity that holds a license to feel and think that they do have some form of right to the water that the license allows them to take. What we have learnt from the meeting in Manjimup is that the Department of Water is slowly and sometimes substantially altering licence conditions when those licences are up for renewal. And those substantial changes could be to the quantity of water allowed to be taken, to the time of year when that water can be taken, and somewhat strangely to replacement of water within particular structures like dams, etc., where levels might drop below a certain point. So there's some pretty weird things happening in relation to licensing, and as I said, some of those changes appear to be quite substantive. So where a license holder has had these substantive changes made on the renewal of a license, many people are thinking that they should have a case based on that loss of the water right. And this is where we come back and turn back to what is water, and what does a license actually grant. And the argument is that the license grants a water right, or a right to water, and the argument flows from there, such that that water right becomes a property right. So the individual has a property right in the water allocation from the license. Now this is not necessarily new law, but it's not settled law. So the question of whether a water license grants a proprietary right in the water itself and in the conditions of the license is still law to be decided by the courts. The legislation doesn't deal with this, so it is an ambiguous issue. To my way of thinking, where a license has been substantially amended, then yes, something has been taken which was originally granted to the license holder, and there should be some remedy available. Now, there are some processes that an affected license holder can look to. They could commence an action in the State Administrative Tribunal for a review of the department's decision to amend the licence. They could commence an action in the Supreme Court of Western Australia under what's called a judicial review process, where the department's amendments are reviewed by the court, and so that's then a court-based review. And the difference between a judicial review and a administrative review is that the judicial review is based on precepts of law, whereas the administrative review is simply based on public policy and whether or not the decision of the department was right in the circumstances. And doesn't necessarily need to deal with or cover the concepts of law. So two forms of review, but each dealt with quite separately and differently, and each liable for a very different outcome. A third potential avenue of redress for a licence holder that has had their licence conditions significantly affected is to pursue a claim again in the Supreme Court for injurious affection. That's where effectively the state has taken away a right that you've previously enjoyed and has not paid you anything for taking that right away. And we can't really confuse this with taking property on just terms, which is a constitutional right where the Commonwealth takes property from you. This is a common law action called injurious affection. As I said, those things and those review mechanisms, perhaps other than the administrative review process, would be based on a precept that the licence holder has a proprietary right in the water licence or a bundle of property rights within that water licence that they're seeking to enforce. Okay, so they're the potential remedies and reviews, really. When it gets to the point of administrative review or judicial review, the SAT tribunal or the court will invariably turn to the relevant legislation for some guidance. When courts and tribunals turn to legislation for guidance, they don't necessarily limit themselves to the legislation per se, but they will also turn to green and white papers where legislation is proposed. They will turn to explanatory memorandum where the government has provided policy basis for what it's seeking to do with the legislation, what mischief the legislation is designed to counter, and the courts and tribunals would also look at parliamentary debate. What has happened? What's the nature of the debate within Parliament? And how does that influence or affect an interpretation of a statutory requirement? Those are quite key things for courts and tribunals to turn to. What transpired at the meeting in Manjimup was that there is a fear that the current government will not fall back on those traditional parliamentary processes of issuing a green paper or a white paper or explanatory memorandum, and won't release the draft legislation for public comment or indeed for review by the opposition parties prior to it being tabled in Parliament. And in those circumstances, where it comes to interpreting legislation, a court is then bereft of understanding what Parliament may have intended by the new legislation it's introducing. So there is a solid basis, really, to continue those traditional parliamentary processes to assist future interpretation exercises. And that could be by a court, or it could be by legal people. If we're asked to provide some interpretation on new legislation, we also look at those explanatory memorandas and Hansards and public comments to guide us in the interpretation process as well. And if we don't have those things to help and facilitate that process, can be very difficult to understand what a government's actually trying to achieve and what the true meaning of legislation is. So that is one of the key issues that came out of the meeting down in Manjimup is there's this fear the government won't follow traditional process, and there's a real fear amongst growers and parliamentarians that yes, the government won't follow that process where it really should. And so when we get to the interpretations of legislation, of course, leads me to the last point. If there's ever a prosecution, if someone has been prosecuted for alleged failure to comply with their licence conditions, they've taken too much water, they've taken water outside the allowable period of time, then it becomes important from an interpretation perspective to understand the legislation in such a prosecution, because you don't know where a defence might lie. So again, the process of Parliament becomes important where a prosecution is launched by the government. So I will leave it there. I've probably gone a bit over time, really. I was trying to limit this talk to 15 minutes, but there we go, slightly over. Nonetheless, if you seek or need advice or assistance in relation to water licensing, please don't hesitate to contact us at Baileywick Legal. We have experienced personnel who understand the nature of the agribusiness environment and have expertise and experience with water issues. We value the personal approach and practical solutions and application of law and try and cater for your individual situation. And we do offer a 30-minute consultation for free. So keep safe and well. Bye for now.